$100,000 cash or surety with the conditions as listed. The bond can be revisited if you do not post it at the time of the pre-exam conference or of the prelim. This is a very serious charge, very young child, multiple occasions.
Welcome back, everyone. Today, we're diving into one of the most tense and emotionally heavy courtroom sessions you'll see. We've got Judge Patterson stepping in, a defendant facing charges that could land him behind bars for life, and prosecutors laying down serious arguments. From shocking accusations involving a child victim to heated bond debates that push the courtroom to the edge, this case has it all. Stick around, because the twists in this hearing are going to leave you stunned.
I have a physical this afternoon. I thought I'd prepare by having a brisket sandwich and an ice cream cone at the fair. My doctor's not going to be very impressed when I get there. All right, we are about to take up some jail arraignments. The magistrate is at the magistrate conference. So Judge Patterson and I will be sharing the arraignment duties for the next couple of days. And I knew of these two cases this morning, but I was certain that the prosecutor would want to have input on them. So I said we would try to do them at 2 o'clock. Mr. Stickley, the chief public defender, is present with us. And also present is Angelique Canfield from the prosecutor's office, and their victim advocate is also present. Good afternoon, sir. What's your name?
Cody McCoy.
All right, Cody Edward McCoy. Mr. McCoy, I'm Judge Vincent. You've been charged with a very serious offense. Let me get to it. Darn it. Sorry about that. Let me get at it. She can have a seat here. We'll be with her in a minute. As I indicated, this is file number 251883, Cody Edward McCoy. Mr. McCoy, the allegation in this case is from January of 21 to July of 24, sometime during that period. That's
right here is where the weight of the courtroom hits. The judge isn't just reading minor violations. These are first and second-degree criminal sexual conduct charges against a child under 13. That's the kind of allegation that immediately raises the stakes to maximum. What's your take? Should a judge lean toward strict pretrial detention in cases like this, or balance it against a clean prior record?
It's a pretty broad period. You did engage in sexual penetration with a child less than 13 years of age. That is a felony, punishable by up to life or any term of years. Second count is criminal sexual conduct in the second degree. It's alleged that you did engage in sexual contact with the same child who was less than 13 years of age, and that is a felony, punishable by up to 15 years imprisonment. Count 3 is another count of criminal sexual conduct in the second degree. One count of criminal sexual conduct first degree and 2 counts of criminal sexual conduct second degree. Those are very serious charges, punishable by up to life imprisonment. First thing I'm going to do is I'm going to indicate that you're going to plead not guilty to these charges. You have a right to hire a lawyer, but I'm going to make sure that you have one. I'm going to appoint an attorney for you. set a pre-exam conference for September 30th at 8:30. And if we need a preliminary examination, it would be October 7th at 1 o'clock. Mr. Moore, what's your occupation?
Mr. Moore or Mr. McCoy?
Oh, excuse me. Mr. McCoy, I'm sorry. I was looking at another file. I wonder
I'm
you are. What's your occupation? Do you work someplace?
I'm a welder
Where's that?
at a low fab shop called Ash's Fab. It's just me and the boss.
And where is that?
White Pigeon. I'm not sure of the exact address.
How long have you worked there?
Since May, I believe.
Now, this is alleged to have occurred in Sturgis. Do you still live on Airline Road in Sturgis?
This moment might feel casual. Just a man saying he's a welder, lives near his grandmother, but legally it's critical. Employment, stable housing, and community ties are factors courts weigh heavily when deciding bond. The defense will later lean on this stability to argue he's not a flight risk. But does that outweigh the gravity of the charges?
Yes, sir.
All right. Are you on probation or parole?
No, sir.
Have you ever been convicted of anything like this in the past?
No, sir.
They didn't list any supplemental. This is shame on me. I don't have a criminal history in here. I didn't see anything in my system, but I didn't see anything elsewhere. Have you been convicted of anything in any other state?
Just the OWI,
And where was that?
Indiana.
Who do you live with?
Just myself. My grandmother owns the property and the property next door. She lives on the property next door.
All right, as I indicated, Mr. Keith Stickley is here. He'd like to speak with you privately in what's called a breakout room. And I wanted to get some of the particulars out of the way. And I'm going to put you in a private space where you can talk with him, and then we'll talk further.
Okay.
I didn't get any praxis information or anything on this case. And I didn't get a criminal history. And I didn't ask for one, but I didn't see much in our system.
I'm only seeing some things from Indiana as he's claimed.
Thank you, Your Honor.
It take me 30 seconds to bring him back.
Your Honor, what was the date of the pre-exam conference again, please?
The date of the what?
The
Pre-exam is 9/30/25 with a prelim 10/7/25.
Thank you, Judge.
14 seconds. All right, Mr. McCoy, one of the things I need to do at this hearing is set a bond.
Now watch closely. This is the part that makes or breaks the defendant's chance at freedom before trial. The prosecutor is about to explain why bond should be denied or set astronomically high. When you hear her reasoning, ask yourself, if you were the judge, would you gamble on releasing someone accused of these crimes, even with restrictions?
The first charge is what's known as a capital offense. It's punishable by up to life imprisonment. The prosecutor's office is here, and I'm sure they'd like to speak to that issue. Ms. Canfield, what would you like me to know about the prosecutor's input regarding bond?
And thank you, Your Honor. As I'm looking at MCR 2.306, no, I'm sorry. 6105, no, it's 6106. Parents B1B. It does indicate the court has the authority with a criminal sexual conduct, first degree armed robbery or kidnapping. If they find proof that the defendant's guilt may be evident or a presumption is great, the court can deny pretrial release under that circumstance. This is one of those difficult cases, however, where it is a young child who disclosed to another child. I'm the one that authorized this particular case, so I'm very familiar with the facts. I did view the interviews of the child after the original disclosure to the sister. The children then went to the mother. The mother then called, as appropriate, the police, took the child for examination, and then subsequently for a forensic interview. There were disclosures not only to the sister, but to the forensic interviewer that in my training and experience as a prosecutor for over 15 years and a criminal attorney for almost 29 now, that there's a preponderance, at least a very strong one, which is why I authorized it the way that I did. Now, when we look at his criminal history, it is accurate. There is only, to my understanding, no Michigan history and an Indiana history of only an operating while intoxicated, and that was in 2017. When you look at the factors under 6106F, he doesn't have a significant criminal record or one that indicates these types of crimes happening previously. He appears to have resided in the community for a period of time, and his ties to the community would be the fact that he is employed and has a home and apparently his grandmother in the area. My understanding is that the child currently resides out of the state and only came into the state for parenting time, which is allegedly when these offenses occurred, was during the parenting time. So my understanding is that there is no contact between the minor child alleged victim and the defendant at this time, and hasn't been for quite some time since the disclosure. So I can give the court that information. That is a very serious offense, which obviously falls under for F, let's see, F1E. The seriousness of the offense can be considered as along with any threats or whatnot to the victim. Because there is no contact and the minor child resides out of the state, one would think that the risk factor would be less or lesser than if they were residing together at the time. But my concern in instances like this are, if he's released, he does have the ability to travel. I'm presuming he has a vehicle to get to and from work. She doesn't live very far out of the state. So that is a concern. She is very young. And it's his own child that's the alleged victim. So that also causes concern of the defendant being on bond release and around any other children. So if there is a bond set at this point and it's not denied under 6106B, I would request that the court put in a no contact provision for the victim, her sister, and the mother of the minor child, that there be a no contact provision with any child under the age of 16 without supervision, and that the court consider a tether, although I know, depending upon where he is employed and his financial means, that may be a little bit straining on the defendant, but a tether with GPS that places him in the state and at his place of employment and residence, so that we know if he goes outside of that zone or attempts to leave the state, we'd have a little bit more alert for the safety of the victim if that were to occur. I think there should be no alcohol and illicit substances other than those that are prescribed by a physician while on bond. And that we'll see he and his counsel on September 30th.
All right. Mr. Stickley, you have any input regarding bond?
I do, Your Honor. I would have to stipulate that and agree with the people that this isn't, in fact, an offense that potentially the court rule regarding no bond would be applicable. And I guess I appreciate Mr. Counsel laying out I guess would be a good chunk of my argument that that being said, there are some mitigating factors, I think, to his benefit that would show that there is not necessarily a immediate risk to the community and or his ability not to show up. He doesn't have any sort of criminal record or track record of not appearing in court. I would ask that the court set a bond, the court set an equitable bond, perhaps even a PR bond with electronic monitoring. That might be very appropriate in integration with community corrections. I think that's the reason for community corrections.
And here's where courtroom strategy takes center stage. The defense pushes for a PR bond with electronic monitoring, painting the defendant as reliable, not dangerous, and willing to comply. But prosecutors hit back hard, stressing the victim's age, disclosure details, and community risk. This clash is the essence of criminal law, freedom versus protection. What side are you leaning toward?
Any alleged victim, as has already been put on the record, I don't think resides in the state. I don't think that there's been any contact between the two. I'm hesitant to give a full timeline, but my understanding it's been the greater part of a year, maybe more. In terms of him being a flight risk or not participating in court, which is obviously the purpose of bond, is community safety and ensuring showing up to court. My understanding is I think that this gentleman knew that this was sort of kind of out there and did not remove himself from the situation or run. He allowed himself.
I got the impression this investigation had started once before and stalled out, and it got resurrected.
So he absolutely promises to show up to court. I don't think that he's run. I think that there's been that opportunity if that was going to be the case. He's asking the court to grant him perhaps even a PR bond with conditions, and no contact is kind of a no-brainer. We'd have no problem with that whatsoever, and enforcement however you'd like.
All right, thank you.
Your Honor, I think what happened with any delay in charging is the fact that this was a very young child initially when it occurred, and it was disclosed to the sister a little bit later. And then because the investigation began out of state, that agency was involved there in Indiana, as well as Child Protective Services in Indiana, that then realized that the actual event occurred in Michigan jurisdiction at the defendant's home during parenting time, which is why it was then shifted to an agency here to complete that investigation and submit for charging. It was at the office and was assigned to me after I became employed here in July. And I did take the time to review the evidence and the videos of interviews before I authorized what I felt were the appropriate offenses.
All right, thank you all for your input.
However, in a case like this, I respectfully disagree with Mr. Stickley. Although we have a victim out of the state, when we have any criminal sexual conduct that's alleged to have occurred, there does appear to be a risk to the community, and particularly the children that are minors.
All right, I'm gonna order some bond conditions and no drugs and no alcohol. No contact with the complainant, NM, her sister, whose name I don't know, or her mother, and you know who those parties are, or any child under 16 years of age without adult supervision. You're not to possess any weapons or firearms and not to engage in any assaultive or threatening behavior. If you are released, you're to be under the supervision of the St. Joseph County Community Corrections with a GPS tether. When I was prosecutor, I handled literally hundreds of criminal sexual conduct cases. That sounds terrible even to say it. I tried 46. I had 2 people today in my court that were child victims when I was prosecutor. From the affidavit, this case seems to rest solely on the shoulders of a 6-year-old girl. I didn't see anything else. I didn't see any forensic evidence like DNA or anything like a recorded phone call or a fingerprint or that sort of thing. There may be a medical evaluation of the child that occurred, but I didn't see it as part of the affidavit. It's entirely her testimony.
This ruling is a pivotal moment. The judge acknowledges the lack of forensic evidence. No DNA, no recordings, just a child's testimony. Yet, that alone carries enough weight to justify a $100,000 cash bond. It's a reminder that in cases involving children, testimony can be as powerful as physical evidence. Do you agree with that balance of trust?
As a very young child, about things that happened to her when she was younger still. I'd fall off the cliff of the earth if I were to grant a PR bond in a criminal sexual conduct first-degree case. Bond in this matter is $100,000 cash or surety with the conditions as listed. The bond can be revisited if you do not post it at the time of the pre-exam conference or of the prelim. This is a very serious charge, very young child, multiple occasions. That's my ruling. So the bond is $100,000 cash or surety with conditions as stated. If you do post the bond, you need to immediately check in with Community Corrections Department. And that information is on the bond form, and contact your attorney. If you don't post the bond, which is what I expect, your attorney will be coming out to see you at the jail in preparation for that pre-exam conference on September 30th. Mr. McCoy, you're free to go back with the court's jail staff.
Thank you.
All right, thank you.
When they redo the courthouse, they're going to throw away all the stuff that's in the basement. there's a room that has several hundred videotapes in it, including more than 100 confessions to criminal sexual conduct by defendants like this one. It was a different time, a different world. We had a polygraph operator on staff who was an excellent interviewer. And I have more than 100 confessions to child criminal sexual conduct. Or at least you do, your office is in possession of those records, but so such as it is.
Do we have one more at the jail, Judge? I think the jail left, or maybe you put them in a room.
Stalking, and Ms. Wainwright is here from this morning. You weren't here, Jeanette was. She was on her way. I guess it took her longer than we thought, but she is here. So we're going to do one regular arraignment. Good morning, sir. Or good afternoon. Are you Scott Lynn Jones?
Yes, sir.
This is Judge Middleton.
How you doing today, sir?
I'm doing all right. I've got here with me Keith Stickley. He's the Chief Public Defender, and Ms. Angelique Camfield from the prosecutor's office, and the victim advocate is also present. Mr. Jones.
Yes, sir.
I want to tell you what you're charged with.
Okay.
You're charged with aggravated stalking. It's alleged that you did engage in a willful course of conduct involving repeated or continuous harassment of Catherine Ganger, the contact being such that would cause a reasonable person to feel frightened, harassed, intimidated, and threatened. And such conduct would actually cause Catherine Ganger to feel frightened, harassed, intimidated, and threatened. That's a 5-year felony. You're also charged as a 4th habitual offender, which I believe would make this punishable by up to 15 years imprisonment. This was alleged to have occurred here this summer, June 29th and June 30th. How did you come to get arrested?
I went to check into my bank account yesterday, come to find out that all my money was gone off my bank account, and I've been sick for the last year. I've lost 86 pounds.
Well, where were you when you got arrested?
I was at home. I pulled up at home and the officers were there.
In Kalamazoo?
In Kalamazoo, yes.
All right.
And as far as June 29th, and I wasn't even around them. I was at home in Kalamazoo, and I don't know how I could stalk them if I'm at home.
Hang on, we'll get to that, sir. We'll get to that.
Well, according to the affidavit of probable cause, I was dispatched to Village of Constantine on June 30th regarding text messages to his ex-wife, Catherine Marie Ganger. Some of this is like deja vu all over again because you had an earlier case with Miss Ganger.
I haven't texted her since.
Hang on, sir. Let's not go there. We're not gonna figure this out today.
I can't hear you, sir.
All right. Well, don't say anything. But
Okay.
they've got the phone. They've got the phones, and
I mean, because I was served with a PPO order, and
Right.
the guy brought all my stuff back.
Sir, let's not make any more statements, okay? We would ask the court to enter a plea of
All
not
right.
guilty.
Anyway, the messages are very troubling. She said, I have surgery scheduled the next day. Scott said he was going to go to the hospital and stab her if he didn't get the things he wanted. The following are the text messages that I received from Catherine's phone. Since you're not answering, I'll be on my way out. I don't give a fuck if the police are there or not. And then I'm taking all my fucking shit and they're going to have to kill me. I'll see you Tuesday the 1st. It'll be one of the first things you see that will scare you. I'll be waiting for you at the hospital for you tomorrow. You won't even know where I am until you get it stuck in you. Matter of fact, if my shit doesn't get returned, my grill, my lawnmower, my tent, and all my stuff, I will take care of it, but illegally if I have to, but my shit will get back to me. I'll see you in the hospital in the morning if you don't write me back. I'm praying to God that you die tonight before I see you in the morning at the hospital. That's the kind of messages they received off your phone. Now, I dealt with you two as a couple back in 2020. Same sort of thing. Text messages threatening to kill her. That was charged as a felony. I believe it was bound over to circuit court. And you had an earlier case in 2016, and I don't remember if that was Miss Ganger or not.
Yes.
So they're treating this quite seriously. Is the PPO out of Kalamazoo County or St. Joseph County?
Out of St. Joe County. I was served with that. I think in July, actually, they had arrested me for a violation of PPO order on my girlfriend that I had then, and then they dismissed the case because Catherine Ganger called the police, told them I had a warrant for that. And then when I get out, I got hit with a PPO order from her. And I leave her alone. I don't go nowhere near her. I leave her alone. All I wanted was my stuff back.
Stop.
All right,
Sir,
stop,
don't make
Jeff,
more
don't say
statements.
more about it. Well, that ain't how you go about doing it. Stop. Mr. Stickley's right. I'm not mad at you. I just don't want you to say something that could implicate yourself, even acknowledge that you had contact with her. So I'm going to do the same thing. I'm going to appoint an attorney and set pre-exam conference for 9/30/25 at 8:30 and a preliminary examination for October 7th.
So is there a way
Yes.
I can get a PR bond or an OR bond? I have doctor's appointments for my stomach. I've been back and forth. Like I said, I've been sick since November of last year. Like I said, I've lost 86 pounds. I'm trying to find out what's wrong with me. I was supposed to have an MRI at 10 o'clock last night, Bronson and Battle Creek, and I couldn't make it because I was arrested. They're trying to find out why I'm losing weight and I continuously lose weight. I'm just trying to keep my doctor's appointments in order. I care a lot about Catherine. I didn't mean to say any of that stuff if I said it.
No,
That's what I don't know.
Stop making statements. So, Your Honor, he's asking for a bond to be set fairly and equitably, hopefully with a PR bond.
He ain't getting a PR bond. Stop. We could start at 1 million and work our way up. I'm very concerned about these threats. I had some in 2016. I had some in 2020. I hope you die before I get there in the morning. You're going to wake up and you're going to see me before I stick it in you. I'm not sure exactly what that is in reference to. Ms. Canfield, what's the prosecutor's position here?
Your Honor, the prosecutor's position is that under 6106F, The factors and analysis of them would indicate that this man is a danger to not only Ms. Gagner, but to the community. And he has a very violent criminal history. I don't know that he's a flight risk if he's ill and has employment in Kalamazoo. However, there's a 1983 destruction of fired police property, a 1988 conviction for a traffic offense, an 88 conviction for assault and battery, 94 assault and battery, 96 domestic violence, 97 domestic violence second offense, 99 there was a home invasion and domestic violence that got dismissed. I'm not sure what led to that, but there's a conviction in 2000 for assault with a dangerous weapon for which he was confined in prison. Another conviction in 2000 for drunk driving. 2000, there were malicious phone calls and another assault dismissed in that year in 2001. There's a resisting and obstructing with probation revoked in 2005. Assault and battery in 2007. Domestic violence third offense in 2008 with a 6-month jail confinement. Another 2010 assault with a dangerous weapon and DV third bound over to circuit court. I see a conviction on the assault with a dangerous weapon in 2011. Confinement 2 to 8 years in prison. Malicious calls again in 2010, marijuana 2010, another domestic violence second 2011, strangulation, pled guilty in 2017.
That's here in St. Joseph County. That's
Correct.
163,
And then aggravated stalking conviction in 2021. Again, a prison term, and yet here we have again Mr. Jones coming back before the court on another very serious offense with a lengthy history of assaultive crimes. So I do believe he's a danger not only to the alleged victim but to the public, and I would ask that the court set high cash bond.
Mr. Stickley.
I simply ask that bond be set fairly and equitably. I have nothing else.
All right.
Sure. I'm just trying
Yes,
to make it.
Mr. Jones, I'm going to mute your microphone. I'm sorry about your medical circumstances. This is all on you. This is all on you. Your all baggage has come home and landed on you. I'm in an absurd position that I'm inclined to set this bond higher than a criminal sexual conduct first degree. Bond is $250,000 cash or surety. Mrs. Ganger shouldn't have to live in this fear for this long. Yes,
Is that a bond condition?
yeah.
This is the new. I need to.
I thought I
these-
threw those
I
away.
need to take these from you.
Was this the last one? Is that this
This
one?
is the brand, this is, no.
All
this
right,
is
they
brand
were
new.
filling them out and
Yeah,
putting them in as
that's,
part
we're
of
trying to
this.
get clarification on that. but I did take these out.
All right.
so I apologize on that.
No contact with Catherine Ganger. No assaultive behavior. I've never seen this form before.
It's new this week, Your Honor. They're kind of making a transition.
Mr. Jones, I don't expect you're gonna post this bond. The attorney will come out and see you at the jail and discuss this. You may want to share with him your medical appointment schedule, and that could be discussed further at your other hearing. But I'd like to have some input from the prosecutor's office and Ms. Ganger, but this is all on you. Your history came back to roost, and it roosted in the amount of $250,000 with a no contact provision. All right, you're good to go, sir.
And there it is, two defendants, two very different charges, but the same theme. The court is not taking chances when safety is on the line. From child abuse allegations carrying potential life sentences to threats of violence against an ex, both cases end with heavy bonds and strict conditions. These hearings show us how judges balance legal rights, community safety, and raw human emotion inside the courtroom. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
He's speaking sign language, but I don't want him to say anything else to implicate himself. All right, I have to be there at 3:45. I'm cutting it close. Ms. Chuck Stickley, if you'd stay with me, Ms. Rainwright's about 5 hours late for her arraignment, but she is here. And we'll address her case. Would you come forward, please? Come right up to the podium. Right there. Let me see if my case is still even in here. Here it is. Good afternoon. Are you Sarah Wainwright?
Yes, I am.
You live in Garrett, Indiana?
Yes, Your
And
Honor.
where is that?
Close to Fort Wayne, Indiana, if you're familiar.
Yes, all right. You got arrested on June 29th for operating while intoxicated, having open alcohol in a motor vehicle. Operating while intoxicated in Michigan is a misdemeanor. It's punishable by up to 3 days in jail and a fine of up to $500. You had run off the road in June. There was alcohol in the vehicle. They give you a test, and the result was 0.096. Mr. Stickley, I'm sure your recommendation would be that she plead not guilty and I appoint an attorney for her.
Absolutely, Your Honor, yes.
Is that agreeable with you?
Yes, Your Honor.
What's your occupation, ma'am?
Currently unemployed.
Now appoint an attorney, set an attorney pretrial for October 3rd. We're going to give you some information with your attorney's name and number on it. I want you to call that attorney and make an appointment to discuss this with them. You don't seem to have anything on your driving record that I could see. Maybe there's some Indiana stuff.
No.
I don't see anything.
That's correct.
All
There
right.
is nothing.
Well, how come you weren't able to get here this morning?
First off, I want to sincerely apologize for that. I had incorrectly written down tomorrow as my court date, and ended up finding out it was today. And I was in a different location at the time I found out.
All right, well, you're here, so there's no need to do a bench warrant. We did the arraignment, we just did it quite a bit later. So the court office is going to take you out to the court office. You're going to get an attorney appointed for you. And the attorney pretrial will be 8:30. That's early in the morning. It's probably a 2-hour drive up here from Garrett, Indiana.
Yes, Your Honor.
But it's at 8:30, and it's important that you be here.
I will.
You're entitled to hire an attorney of your own choosing if you wish, but I want to make sure that you have one. So you go with the court officer, and I'll see you on October 3rd at 8:30.
Thank you.
All right, thank you.
Was she the one that needed fingerprinted?
I thought she got printed.
I haven't, so.
All right. You go with the officer. You may need to have your fingerprints taken. All right, thank you,
Okay,
Keith.
thank you.
Well, things were a bit herky-jerky this afternoon, but we finished everything. I have 20 minutes to get where I need to get to.